Now, the Helen Suzman Foundation has launched legal action over the Cabinet's decision to terminate the Zimbabwean Exemption Permit. The decision was taken in November. The foundation says the process allowed little time for notification and public consultation. Advocate Nicole Fritz, who's an executive director at the Helen Suzman Foundation, joins us now to explain their legal challenge. Nicole, good evening and thank you very much for your time. So your position is that you're not necessarily saying extend the ZEP, neither are you promoting for people to stay in the country illegally. So what exactly are you challenging?
Good evening, Tava, and that's correct. I mean, the position is not that we say the Zimbabwe Exemption Permit should be extended in perpetuity, nor that those who are in the country unlawfully should be permitted to stay. But the fact is the recipients of the Zimbabwe Exemption Permit have now lived in this country for well over a decade. They came to this country in circumstances of tremendous endangerment. Many were fleeing the post-election violence in Zimbabwe, 2007 and 2008. Part of the reason for putting in place this special permit system was that the numbers were such that they potentially would overburden our refugee and asylum reception systems. As I said, they've now endured for over a decade. Those who hold these permits have built careers, families, homes here in this country, and they essentially, without any notice, without any consultation, have been told that the permits will come to an end at the end of this year, that unless they have migrated to an alternative visa, which in fact is an illusory option, the vast majority of these permit holders will not qualify for any other existing visa, that they will then be put to this choice, that either they remain in South Africa as undocumented migrants with all the vulnerability that attaches to that status, or they must return to Zimbabwe, which is effectively unchanged from the country that they fled more than a decade ago. And we are saying the manner in which that decision was made, with so little notice and without any consultation with those most prejudicially impacted by this decision, is unacceptable. It can find no support within our constitutional dispensation, and in fact it treats these people and their lives as if they are of no consequence.
Yeah. So, I mean, the department, of course, sticking to its guns on this particular matter, not backing down. In fact, on May 13th, I think, Home Affairs issued a notice encouraging ZEP holders to apply for waivers and permits. The Director General is quoted as saying the Department of Home Affairs has thus far received few applications. Is there any reason as to why there were few applications?
Well, for one, as I say, I mean, the idea that there are mainstream visa options available to those Zimbabweans who have fled is illusory. I mean, the vast majority of those who hold these permits will not qualify for any other form of visa. The other thing to take into account is that there are huge backlogs at the Department of Home Affairs. So even if people are making applications, the idea is that those applications would have been processed and will be processed by the end of December this year, again, is really, I think, an illusory suggestion.
Yeah. So are you then calling for Cabinet to extend the grace period at least to allow the people more time to regularize that status?
Well, we're saying that they need to revisit the decision. The minister needs to revisit the decision, and he needs to do so in a procedurally fair manner. He needs to do so by observing the basic tenets of a fair and just process as set out in our Constitution. And that means consulting with those who will bear the prejudicial impact of this decision, and that there must be notice so that people can plan their lives. And it's not only, of course, those who hold these permits, and we're talking around 180,000 Zimbabwean nationals, but the many thousands of children who have been born in this period in South Africa, who have never visited the country of their parents' origin, whose lives essentially are being left in limbo by this decision. So it is they also who must be considered, and the impact of this decision on them that must be considered. And so, yes, what we're saying is you must revisit this decision, and that decision must be taken in a manner which is consistent with a procedurally fair process, which allows those who are impacted to make representation, to be consulted, and to have adequate notice.
Yeah. And what do you make then of the position of the presidency to say these decisions are not taken by individuals, but a collective? So it's a decision that was taken collectively by cabinet, supporting the rule of law of the country and the sovereignty of the country, so to speak.
Well, the fact is that the Minister of Home Affairs has indicated that he has made the decision, and certainly the announcements and the directives have issued from the minister. At the same time, it is a decision that has been endorsed by cabinet, but it doesn't matter. I mean, even if the entire executive made that decision, it is still a requirement that such a decision follow a procedurally fair process, right? And so that people be given the opportunity to make representations, to be heard, when they will bear the prejudicial impact of this decision, to be consulted, and then to have adequate notice so that they can plan their lives. As I said, that they are not treated as if their lives are of no consequence, and they can simply be sort of turfed out onto the streets, remain here in South Africa as undocumented migrants with all the vulnerability that then conduces, or return to a country that is unknown to them. And as I say, nothing awaits them there. They have left more than a decade ago, and it was a country from which they've fled. So to put them to that choice, I think with no consultation, with little notice, is unfair and is not in accord with our constitutional dispensation.
Yeah. And the position then of the government in saying this is our policy. So are you looking for government to change their immigration policy by this? Because I think the minister is insisting that there is a policy in place around these issues, and there is also the abuse of the system that they are seeing here and trying to rectify.
Well, the sad thing here is that there actually is no policy in place that makes this justifiable. And in fact, if you look at some of the policy statements that were put out when this special exemption permit began, which was that, in fact, one wanted to put in place these special permits because there was a recognition of the reality that it wasn't as if Zimbabweans were not going to come across the border. They were. It was about making them documented, recognizing that they were fleeing from, in many cases, from persecution, from what was effectively a civil war, and that the numbers were such that they would overburden our asylum and refugee system. So this was another manner in which we would offer them protection, legal protection. Those reasons for the initiation of these exemption permits remain. There is no policy, there is no justification, any indication that those circumstances have changed. The reasons why the exemption permit were introduced, have ceased to exist. And I think that the concern here is that this decision does not rest on any substantive reason, on any justifiable policy. And it's very difficult to see why this government has changed its mind when you look at the policy statements that support the initiation of this permit system.
Advocate Nicole Fritz, appreciate your time. Thank you very much for coming on, Executive Director at the Helen Suzman Foundation, and taking this to court to argue this particular matter with the department and the decision that they've taken. They're saying, let's take this decision for reconsideration.